Well, Section 2.1 in our book has a lot of information, but not as much as Section 2.2, the next part that follows this one. These are two that are really, really important to understand, so you may need to listen to the videos a couple of times to really get the key ideas. I tried to see if I could split this up into several pieces because it's a good bit of material, but there's not a real logical place to split it up. So we're just going to get into it, and it lasts as long as it lasts. I want to make sure, as I said, that you really understand some of these laws. There's test questions, but there's even beyond that, real practical application for your role as a manager to understand these things. Now, keep in mind that laws are passed in the American society to remedy wrongs, and employment laws in general are passed to correct problems that society sees as being disadvantageous to some folks. So the equal employment opportunity is that category of laws is a series of laws designed to give everybody a fair chance. Over the course of time, it became obvious that certain groups of people or classes of people didn't have the same chance as other classes of people. And you can think back through history, and even to some degree today, women didn't have the same chance that men did. People of color didn't have the same chance that whites did. So laws were passed, and as we have gotten further and further into the working conditions of our society, we found more and more groups of people that don't have the same chance. So the initial laws that were designed to cover what we thought were the biggest categories of people have been added to as we have found more categories of people. There are even categories of people now that we're looking at the possibility of laws to protect that we wouldn't have even thought of 10 or 15 years ago, certainly not back when this all started. So the equal opportunity or equal employment opportunity commission, the EEOC, is an organization that is designed and is tasked with watching the environment, watching the workplace, and making sure that everything is fair, making sure that there's a level playing field for everybody, so everybody gets a chance, everybody has the opportunity to get employment, to advance in employment, to get paid fairly, to get the same kinds of assignments and responsibilities that gives them a little bit of control as individuals over things that they never had control over before. And two important things that I want you to get out of this first section of the text are the ideas of protected classifications and protected groups. Classifications are broader groups of people, and groups are individual segments within those classifications. Why is that important? Because we might say that you're part of a protected group. That's a subset of a classification. All right? So classifications are broad groups of people that have been previously overlooked. Like gender, that's broad. That includes several subcategories, right? Race includes several subcategories. Religion is a broad term that encompasses several categories. So when we ask about classifications, we're not talking about white people. We're talking about skin color, right? When we're talking about classifications, we're not talking about Muslims. We're talking about religious identities, religious affiliations. So distinguish between classifications and groups. Classifications are broad, and within those broad categories, there are some very specific subsets that make us different, right? So theoretically, everybody has some sort of religion. Even an atheist or an agnostic or something, you would say, has a religion of no religion. So there's groups that make them different. Baptists are different than Catholics, that sort of thing. But they all share the classification of a religion or faith or something like that. Protected groups are those subsets of classifications. If I were to ask you on a test, for example, give me two classifications and three groups within those classifications. Well, if you were to say gender is a classification, you could certainly say male and female or groups. And traditionally, that's kind of where we would stop. But now you could say, as part of that group of gender, you could say non-binary, or you could say trans or whatever. So several groups within the classification of gender. You might say, okay, a classification is religion, and several groups, the protected classification is religion, the protected groups are Christian, Muslim, Hindu, Jewish, whatever. So right off the bat, get this distinction down between protected classes and protected groups, all right? So with that broad background in mind, at already 5 minutes into this video, there are several laws that have been developed over the years that help people in those classifications and in those groups to get a better opportunity to experience what everybody else outside those groups has already been experiencing for a long time. The first of those laws that's really significant is Title VII of the Civil Rights Act of 1964. Now understand, most of these laws are huge, and they have like chapters in a book. So the Civil Rights Act of 1964 is a huge document. One of the sections of that document is Title VII. And that's what really we focus on when we're talking about discrimination. So a term that you want to remember is Title VII of the Civil Rights Act of 1964, because Title VII deals with discrimination. Title VII of the Civil Rights Act of 1964 says that a business cannot discriminate on the basis of 5 things primarily: race, color, religion, sex, and national origin. And some of those things kind of overlap today. I mean, race and national origin and color even can kind of interact with each other. So it's broad enough to where we can interpret the way we need to. Those 5 things: race, color, religion, sex, and national origin. And the law said that you can't discriminate on anything related to employment. Those 5 things, color, sex, gender, whatever, cannot factor into your hiring, or your terminating, or how you discipline, or who you discipline, how you pay, the working conditions of that person, the work responsibilities of that person. So what Title VII did is to say, all right, we got a male and a female here. That's gender, right? Gender is covered under this law. We're making the females do the household kinds of things, cleaning the building and making the coffee and stuff like running the errands and stuff like that, while the men get to do the business-oriented stuff. Well, somebody could file a lawsuit under Title VII of the Civil Rights Act of 1964 and say, you're treating me differently because of my gender. And if there's a pattern where we tend to give the males one kind of jobs and the females one kind of job, even though they're equally qualified, there'd be a legitimate lawsuit. So Title VII Civil Rights Act of 1964, anything related to employment, from how we go about choosing somebody, to what we do when we hire them, to how we pay them, to what kinds of responsibilities we give them, to how we give them feedback, to whatever point where it comes time to terminate them. If we only terminate females or only terminate colored people, there's a problem. So the first one, Civil Rights Act 1964, Title VII, right? The second one is the Civil Rights Act of 1991. This one came about, you see, about 27 years later, to amend the 64 Act, because it was found during those nearly 3 decades that there was a lot of burden on the person who was complaining. And the government felt like it needed to be a little bit easier for folks to initiate these complaints in the courts and put some burden on the companies. Because sometimes there's a situation, it talks about in the book, called a mixed motive case. And that is where you have obviously fired me because I'm a female, and that's illegal. Well, no, we fired you because you can't lift 50 pounds, and that's required for the job. Yeah, but I'm a female. Yeah, but you can't lift 50 pounds. So it may be that part of it is that you're a female, and part of it is that you can't lift 50 pounds. So am I discriminating because you're a female, or am I not discriminating because you have to lift 50 pounds whether you're male or female? That's mixed motive. And so 1991 strengthened that Civil Rights Act of 1964 to address issues where there's part of the problem that's illegal, the female part, but there's part of the problem that's not illegal, and to give a little bit more guidance and make it a little bit easier for the courts to reach consistent decisions. The next one the book talks about, and we're talking about pages 35 through 41, by the way. If you're following along in the book, we've moved on to page 39. The Pregnancy Discrimination Act was enacted to help ladies who might get pregnant who are pregnant to be able to function well at their job and to be able to keep their job without having to worry. You can imagine back in the old days that if you're a young female and you're doing really well with your job, they're excited about having you there, they're looking forward to great things, and you come in one day and you say, I'm pregnant, yeah, I'm pregnant, and they think, oh great, you know, well, 6 months from now, you're going to be having a baby, you're going to be out, the last 3 months you're not going to be as effective as you are right now, then who knows how long you're going to be out, you're going to want to be out as a mom for 3 months or 6 months or whatever, you won't be doing any of your job responsibilities then, and then what happens once you've bonded with your baby and your time is up, you may quit because you decide you'd rather stay home. So I need to do something now. Because you have announced you're pregnant, I'm already thinking into the future 6 months, a year, and it's the writing's on the wall, and I need to go ahead and find somebody to replace you. Well, that's discriminating against you because you're pregnant. So the Pregnancy Discrimination Act says that you can't be discriminated against while you're pregnant because it's kind of a disability. A disability in the Americans with Disabilities Act defines disability as something that impairs a major life act. So the ability to not walk. Being in a wheelchair impairs an ability to walk, which is a major life function. And the Pregnancy Discrimination Act said that pregnancy is considered a disability because being pregnant keeps you from doing certain major life functions, but it doesn't last forever. If you're in a car wreck and you lose the ability to walk, you're not ever going to walk again. That's a permanent disability. But pregnancy is not like that. It is a disability, but it's only short-term disability. It's a limited disability. So the Pregnancy Discrimination Act says, yeah, we recognize that pregnancy is a disability, but it's a temporary disability, and yet because it will remedy itself over the course of time, it needs to be protected so that ladies can have some certainty that if they want to come back, they have the ability to do that. All right, the third one is the Immigration Reform and Control Act, and that says two things that are important, especially to remember in society today. Immigration is people coming across the border, legally or illegally. They're immigrating. They're coming to a country that they're not from. The Immigration Reform and Control Act, two of the main things that you want to remember about that law is that this law says that I cannot refuse to hire you. I must consider, don't have to hire you, but I can't refuse to, if you are a foreigner, but you're here legally. So from the perspective of a college professor, if I needed to find somebody to hire to teach HR courses, and I had somebody who was from Korea who applied, I couldn't say, no, I'm not going to consider you because you're from Korea. As long as you are here legally, you've either got dual citizenship or you've got your green card, your visa, whatever it is. If you're here legally, I can't immediately rule you out just because you're an immigrant. So I have to give a fair chance to everybody who's here legally, even if they're immigrants. But it also says that I cannot hire you if you're not legal. Now that's what's a kind of a sticking point in society today, because there are lots of folks who come across the border and who get hired for things, but they're not here legally. And the IRCA, the Immigration Reform and Control Act, says that I cannot legally hire you if you are not here legal. So two things that you want to remember for that. Lots more in those laws, but that's it. The Age Discrimination in Employment Act only helps people if they're over 40 years of age. So if you're a 27-year-old female and there's a 45-year-old female, and the 45-year-old female gets a promotion that you think you're better qualified for, I don't know what you can do to complain, because you're both females. In fact, if the 45-year-old female got passed over for you, she could complain because she's over 40. The Age Discrimination in Employment Act, the ADEA, says you cannot discriminate against someone who's over 40 by giving preferential outcomes to people who are under 40. Why would we do that? Well, people over 40 probably make more money because they've been doing things longer. So if I need a manager and I've already got your mom working here at $50,000 and I've got you working here at $25,000. If I promote her, I probably go from 50 to 60. If I promote you, I might be able to go from 25 to 30. So I would be cheaper if I could get the younger person, but that's discriminating against somebody who's over 40. So one question on the test, you really need to take into account the technicalities of these things. The ADEA is 40 and above. It doesn't apply to anyone who's under 40, but the age laws are the Age Discrimination in Employment Act, ADEA. That's been significant because the next one sounds a lot like it. That one was the ADEA. This is the ADA. Don't have an E in it. The Americans with Disabilities Act. Commonly shortened incorrectly to the American Disabilities Act. It's the Americans with Disabilities Act because it's an act to help Americans who have disabilities. The ADA says that we cannot refuse to hire somebody who has a disability. And as we talked about with the pregnancy thing, that means the disability is something that impedes or impairs a major life function. So walking is a major life function. Talking is a major life function. Hearing is a major life function. Vision is a major life function. Being able to lift things is a major life function. Driving a car is a major life function in our society. So a disability is anything that keeps you from being able to do that. If you have glasses, if you have contacts or hearing aids, if you have to read Braille, if you have a wheelchair, all those things keep you from doing major life functions. And the Americans with Disabilities Act says if you have one of those challenges, if you're hard of hearing, if you're hard of seeing, if you are in a wheelchair, but you're qualified for this job, I have to give you a chance. I cannot rule you out simply because you're in a wheelchair. If you're qualified, and if there's something small that we could do to help you out, we have to be willing to give you a chance. So if I'm in a wheelchair and I want to get a job as an accountant, and I'm a bang-up accountant, I'm really good at accounting, and the accounting department's on the second floor, I'm in an old building that's 2 stories that doesn't have an elevator, I'd say, well, I'd love to have you as an accountant, but you're in a wheelchair and we have steps and you can't get up to the second floor, so I can't very well hire you if you can't get to the department where the accountants do their work. Not so fast, young man. Are there any things we can do to help you in this situation? You have a wheelchair, sure. All right, and here we have to start thinking with minor assistance. If you could do this job with minor assistance, we have to be willing to give you a chance if you're qualified. So 2 terms that are important. One is reasonable accommodation. So I'm in a wheelchair. I want to get a job working on your second floor in your accounting department. And otherwise, aside from the wheelchair, you'd say, yeah, you're qualified and we would hire you today if it wasn't for that darn wheelchair. But what do I do about the wheelchair? I, as a company, have to be willing to explore reasonable accommodations. Now, what could I do to help you be successful as an accountant with my group? Maybe it's not critical that you work on the second floor. If I can get you a workspace on the first floor, that would solve the problem. You could be an accountant on the first floor. If you could work at home, that would solve the problem. You're an accountant at home. If I could somehow move the accounting group down to the first floor so that you could join them, that would work. If I could put in an elevator, that would get you to the second floor. Now, of those things, what's reasonable and what's not? Well, it's maybe reasonable to let you work from home. It may be reasonable to let you work from the first floor. It may be reasonable to have them move down, but that gets to be a little expensive moving them down. It's certainly expensive to put in an elevator, so we might say that the elevator is not reasonable. The whole point is reasonable accommodations. If it costs too much, if it is too much of an inconvenience to have to do this, you certainly wouldn't want to have to build me a new building so that I could be an accountant. That's unreasonable. Putting in an elevator is pretty expensive. That might be unreasonable, but I might not have much expense at all if I created you a cubicle on the first floor. So reasonable accommodation is something that I have to consider doing to help you be successful. That's not going to really inconvenience me all that much. If you're hard of hearing or you're deaf, maybe I have somebody that comes and does sign language during meetings, and it may not be really expensive. $8 or $10 an hour for those meetings. to help you understand. That might be reasonable. Now, if you're the candidate looking for the job, I can do this job if you'll just give me a chance. The burden now says, candidate, you need to press them for what reasonable accommodations they would be willing to make for you. If they agree that you're worthwhile, what kind of skin are you willing to put in the game so that we can be successful here? 20 minutes into this video, we're about done. So it's not, the burden's not on you, the candidate, to propose reasonable accommodations. The burden is on the candidate to show that you are qualified, that you could do this if it wasn't for my blindness. I could do this if it wasn't for my wheelchair. And you agree with me that I could do this. Now, okay, burden shifts from me to prove I can do the job to you, the employer, to figure out a way to let me do the job. But then the burden doesn't just fall on those shoulders, do whatever you have to do, because the second term, after we've talked about reasonable accommodation, remember that term, reasonable accommodation, the second term is undue, UNDUE, hardship. Undue hardship, UNDUE. Undue hardship is that get out of jail free card almost. Well, you know what, I could do this job if you'd put in an elevator. You're just discriminating against me because you don't want to put in an elevator. Well, no, that is an undue hardship. It's going to cost me $100,000 to put in an elevator to be able to give you a $27,000 a year, 4 years worth of salary almost, to be able to hire you. That's not reasonable. $7,000 to create a workspace is reasonable. $100,000 to put in an elevator is not. So you have to look for reasonable accommodations, but you don't have to do all of them, because some of those accommodations can create for you an undue hardship. The last law that is mentioned in this section on page 41 is the Genetic Information Non-Discrimination Act, or GINA, G-I-N-A. That says that if we are going to do health screenings or things like that, physicals, drug tests, any of that kind of stuff as a condition for employment, we have even during once you're working, if we have annual health assessments or whatever, we have the potential to learn things about you. If they take a blood draw, they can find all kinds of things in the blood draw, like that you are very prone to diabetes, or you're prone to heart conditions, or whatever. If we learn things, especially as it relates to genetics, your mother was very prone to heart disease, so the fact that you are related to your mother and share some of her blood means that you may be related too. Anything we learn like that while we're doing medical testing, physical exams, drug screens, etc., that we say, ooh, red flag, that could cause our insurance to be out of whack in the future, we have to ignore it. We cannot make decisions based upon genetic kinds of information that we learn during these types of processes. Man, see, that's a lot of laws. There's no way to really get you the nuts and bolts of those things quickly. We're at 23 minutes in this video. I'll try to end it up here real quick before we move on to the next section. It's really, really important whether you're a manager or an HR person, especially if you're an HR person, but even as a manager, even as a casual observer, it's important to understand that there's a lot of laws out there that really control what we do when we're hiring, what we do when we're promoting, how we go about paying people, how we go about divvying up the responsibilities of the job. And you just have to look at the news today to look that we're not done. There are still some classifications out there that we feel like we have to deal with because they're not getting a fair chance. So this will be something that is of real importance for a while to come yet. And as you move into management, it needs to be part of your filters as you're making decisions. I cannot let your sex, I cannot let your age, I cannot let your medical history, I cannot let your race, any of those things be a determining factor in my decision. I've got to base every decision on the job and your ability to do the job. If I could eliminate your age, your race, your national background, your religion, if all of that stuff, if you were just candidate A and candidate B, here's the qualifications, A is better than B. Well, it may turn out that A is, got 4 check marks for protected classes, and B is a stereotypical white male. We might defer to the white male when all of that's factored in, but if we can factor all that thing out and we can get to who does the job best, we're not going to have these problems. That's it for now. Let's go ahead and stop this recording and start thinking about the next one. Hope you're enjoying the material so far and finding some practical use for it.